Okay, great. Welcome. This is class number 4, the law of ideas. What I want to do today is explain why intellectual property rights are probably the single most important area of business law. And to do this, what I want to do is show you some interesting materials in Module C. Sorry, Module D on the law of ideas. First of all, let me just make it, well, yeah, let me show you. Let's first talk about Peter Thiel. And I have a film clip that I want to show you, just a small snippet from it, where Peter Thiel is explaining why he invested in the Facebook. As you know from watching The Social Network, he is Facebook's first outside investor, right? Eduardo Saverin, of course, is Facebook's first inside investor. And that's going to generate a lawsuit that we'll talk about in the next module. But in this module, I want to explain why Peter Thiel invested in Facebook. And so I'll do a screen share. Oops. Let me pull up the website. Okay. So this will be, now I'm going to apologize. Peter Thiel, I'm going to tell you right now, he's going to come across as a very smug and arrogant, he comes across like a jerk. But that said, what he's about to say is going to be probably the single most important idea that I could convey to you in this class. So let me go ahead and pull up the Peter Thiel video clip. Now, all of this stuff is in the modules. And so, and I may have closed it by accident. I thought I had everything pulled up. I apologize. Let's see here. So I'm going to go ahead and pull it up now. I thought I had this ready. It was extremely frustrating. I apologize. So obviously you can see I have a lot of tabs open because I have, I'll be presenting a paper where I retrace Adam Smith's steps in Paris during the year 1766. And so I have a lot of research I've pulled up. Okay, here we go. So let's go back into the modules and let me show you then Peter Thiel. And this will introduce the class to a very important idea. And again, I apologize. He comes across like a complete jerk. You know what I mean? Really smug person. And but this is so important. I need to show it to you.
How can you spot a winner as big as Zuckerberg?
Well, it probably would be somewhat misleading to say that all of this could be seen from the very beginning. I had looked at already a number of these different social networking sites, and there were definitely a lot of the early attributes were quite good. They seemed very competent technically, which is actually strangely not true of many of the other companies. But I think one of the other things to always I'm always very focused on this point is not just the product or the abilities of the people, but sort of the third part is what I would describe as the business model, the business strat.
I'm going to pause it right there because I need to apologize. I should have started the clip here where I just paused it. Up to now, Peter Thiel has said nothing really original or new. You know what I mean? He's just saying that, it's not enough to have a capable person running a business. You have to look at the business model and the business strategy. That's just a bunch of buzzwords. So up to now, I'm going to tell you, he said nothing new. But what he's about to say is going to be, I think, extremely important. So I just want to alert you to that. So I'll just pick it up from where we left off.
I think that's often not given enough weight because inventing something new is generally good for the world. It doesn't mean that you automatically will do well as an inventor. In fact, most scientists and inventors end up capturing disturbingly little of the value you create. To succeed as an inventor or scientist or entrepreneur, you have to create X dollars of value for the world, and you have to capture Y% of X. And the one important detail people forget is that X and Y are completely independent variables.
What you just listened to there is it may not be obvious, but what Peter, because again, the smugness, the arrogance, the way he's saying it, but ignore that and focus on the substance of what he's saying. It's not enough to have a good idea, what he's calling the X variable. You have to figure out a way of capturing value from that idea, the Y variable. What he's saying there is extremely, extremely important because think about it, right? It's actually, if you've seen Shark Tank or, other shows that feature entrepreneurs, or if you yourself have tried to come up with an idea for a business, it's actually very difficult to come up with a good idea, right? To come up with an idea for a product or a service that people would want to buy or use, right? And what Peter Thiel is saying that actually is original, actually is super important, is that that's not enough. You first of all have to come up with a good idea, but then you also have to figure out a way of making money from your idea. And this is why I say that this module, the law of ideas, intellectual property rights, is the single most important aspect of business law. Because think about it, right? Without value, without products and services that people would want to buy, right, we don't have any businesses, right? And we're not going to have any businesses if you're not going to be able to capture value, make money from the products and services that you come up with to want to offer to the public. And so this is precisely what the law of ideas allows you to do, intellectual property rights. It allows you to assert ownership over your ideas or the expression of your ideas or over your brands. And brands, trademarks, are going to be a kind of a fascinating aspect of intellectual property right that combines different aspects. So I'll say more about that in detail. Now, let me make sure everybody is muted. I don't know if, let me just double check if my teaching assistant, and just double check if you're muted, because then I want to go into the actual, I want to go into the now substance of the class. Now, what I'm going to do is, intellectual property law is actually 4 areas of law, and it's generally taught in at least 3 different upper level law school electives. There's classes on trademark law, brands. There's classes on copyright law, expression of ideas, works of art, etc. And there's also classes on actual ownership of ideas and inventions, trademarks and trade secrets. I'm sorry, trade secrets and patent law. I was thinking of trademarks, trade secrets and patents are the ways that you can actually own your ideas. So when Peter Thiel, and the reason why I don't show you the rest of the clip is because he doesn't go into this detail. He doesn't explain that it's the law of ideas. It's intellectual property rights that allow you to, if you have a good idea, if you have an X, a good idea for a product or service, that's your Y. That is the law will allow you to then capture the value from your idea because you're the owner. And anybody that wants to use your idea, they got to come to you first. And you have to negotiate with you to pay you in order to use your idea. Anybody who uses your idea without your authorization, who steals it, will also face significant legal consequences. And we'll see that this is one of the main themes of the social network. So the other reason why this is important, this module is the most important, is because just think about it for a moment. Every single product, every single service, all the things that we use in our daily lives, all the things that we buy and sell, all the things that, on the internet that we're using and doing, all products, all services embody ideas. And so this is important, right? Because that's why I call it the law of ideas. Because to me, the word intellectual property is just a fancy word and it sounds like it's foreign, only big companies. No, this is especially important for startups and entrepreneurs. It's how you actually can grow to become a big company. So With that said, what I want to do is, because intellectual property law actually covers 4 areas of law: patents and trade secrets and trademarks and copyrights. And because each of these areas of laws are a separate class, in the law school setting, I'm going to give you a big picture, and I'll use the survey results in order to highlight the main things I want you to know. Now, the good news is that if you do, watch the lecture, you'll be in a great position to do the discussion post without any difficulty, and you'll be in a great position for the quiz as well. Although it is open book, and by the way, I have expanded it from 30 minutes to 1 hour, so everybody has plenty of time. It's designed to be done in about 30 minutes. That's being generous. So I've expanded it for an hour for everybody. Okay, so let's just jump in here and let's do a screen share and let's go into our survey results. Now, I'll put the actually, before I do that, let me put the survey link in case you haven't seen it. It's in the chat. There we go. Is that the right one? Yeah, so that should be the right one. Perfect. And what happens is, when people put comments, you don't see when I first put it. I'll put the link when I play the theme song for the class, and then but I just put the link again. So go ahead and do the survey, just a few questions, and then by the way, many of you have written to me like maybe you missed the first survey because you added the class after. Our class is on Tuesday. The add date is what, Thursday or Friday of the first week. Maybe maybe you missed a class. So you have to complete 5 of the 6 surveys, in order to get full credit. So it's okay if you miss a survey. Just want to throw that out there. I have been responding to everyone by email. I've been a little bit tardy because of my travels and my Adam Smith project, trying to get in the zone, my flow state. So, but my TAs have been helping me, and I've also been personally responding to the emails as well. So if you do have any questions or comments or concerns, I'll open it up at the end of class, and then I'll also be responding to everyone's emails as well that I didn't get to. I did respond by the last evening, but I'll continue being a good citizen and responding to emails. All right, so everybody should have had a chance now to do the survey. So I'm going to jump in now into the screen share and pull up the survey. And I'm going to go ahead and close Peter Thiel. By the way, one more thing I should say about Peter Thiel. I'll show you him there. The movie does show you, the moment that he tells Mark Zuckerberg, I'm going to invest $500,000 and in your company. And it's kind of a remarkable scene because this occurs in July of 2004. The Facebook is launched, and you see there's a Harvard Crimson article I was showing you while I was waiting for the class to while we're doing the theme song, everybody getting on board and the survey. There's a Harvard Crimson article from February 9th. In fact, the Facebook was launched on February 4th of 2004. So in the space of, imagine, like right now we're in June 7th, right? Imagine on October, somebody gives you $500,000, for your business idea. That's exactly what happened here. What the movie doesn't tell you, what the movie makes it sound like it's Peter Thiel investing in the company, for a percentage, your typical deal, but no, that's not what really happened in real life. Is that Peter Thiel, the $500,000 investment was structured, or legally speaking, it was structured as a loan, but the loan would be forgiven. That is to say, Zuckerberg wouldn't have to pay it off if he obtained a member within a calendar year. So basically, a million members, a million, Facebook users within a calendar year. So that is to say, if Zuckerberg was able to get 1 million Facebook users by February 3, 2005, then he wouldn't have to pay off the $500,000. In essence, what Peter Thiel was doing when he basically gave Mark Zuckerberg the $500,000, you have to trust me on this, that by July, Facebook was on a pace to get 1 million members within a million users within a calendar year. And in fact, I believe Facebook, one of the fastest growing companies in terms of user base, I think by November of that year of 2004, they crossed the 1 million person threshold, user threshold. In fact, they got it grew way faster than Twitter
Like,
uh,
there's an example of
MySpace.
like
All right,
maxed out.
I'm going to pause right here because
But then some like 10 years later, you would still make it.
super
You
frustrating.
$600 in your bank account, and you start now, you're 21 years old, you want to retire by 10 or 60, that's 40 years. So that's $240,000 for the whole year. An average, I would say a good interest rate would be like 12% return. That still like gets you.
All right, there we go. So I'll just make sure everybody's muted there. That's our offender. All right, so so it's a really remarkable. That's why I say the law of ideas is so important. You know what I mean? Because what Peter Thiel saw in Facebook was a lot of valuable intellectual property rights, you know, that were going to be worth a lot of money, you know. And so let me show you what the Facebook actually looked like on 2004. By the way, I want to apologize to you. I thought I included this in the module. For some reason, it's not in there. So I just pulled it up separately from the Business Insider, and I'll figure out a way of taking a screenshot and including it in there. But Facebook looked like back when it was launched in 2004. And one of the things what I want you to see is I've included this link also in the module is, hold on, let me close some of these other links. I want you to see what the internet looked like back in 2003, 2004, around the time that Zuckerberg launched the original Facebook. Look at the Yahoo website. This was, I'm picking here on Yahoo. I'm showing you Yahoo because Yahoo was one of the most popular websites in the early 2000s and late 1990s. You know what I mean? And you look at this website, it's like amateur night. You know what I mean? Look at this junky, ugly looking website. You know what I mean? Just with a bunch of links. You know what I mean? You know, that's what Yahoo looked like, you know, back around the time that the Facebook was launched. Look at Microsoft, the so-called giant, you know, it's one of the big 5 tech companies today. But even back then, you know what I mean? Look at Microsoft. This looks like an amateur night. Looks like they did this on some like on a PC. Like this is the Microsoft, this big tech company, you know, the original big tech company, right? The original monopoly. And look at this website. Amazon, again, look at this junky looking website. You know what I mean? That's what it looked like back then. AOL is really my favorite in terms of like ugly looking websites back in the early 2000s, late 1990s around Facebook. You know, it's just a real simple, really ugly looking website. You could check this out for yourself. It has a bunch of websites from around this era, even Google when it first launched. Basically, it's like they're trying to copy Yahoo, right, with the exclamation point. And they have a bunch of junky links as well. You know what I mean? My favorite though is Apple. This is what Apple looked like, you know, and Steve Jobs is, you know, his reputation is this design guru. Look at this junk, you know, this is what he inherited when he took over, you know, when he went back to Apple and took it over a second time. Now you go to Apple website, right, you see totally different look, right? Now you go to Microsoft, totally different look, you know. I don't think AOL exists anymore. If it does, very few people use it. Same thing with Yahoo, you know what I mean? Now compare this stuff to the Facebook back in 2004. Look at the difference. Look at the difference. If you saw The Social Network, Jesse Eisenberg, who plays Mark Zuckerberg, right, keeps emphasizing that he has this idea for a clean and simple website. One of the interesting things is that if you look closely, you'll see there is a copyright logo. So we'll talk about copyright law in here. We'll see that you don't know this, but in April, Zuckerberg is going to try to register. He's going to file a trademark registration, I should say, for the Facebook. So the source code probably could be protected by trade secret law. You know, if it's we'll see how you get a trade secret. And now of course Google owns a lot of valuable patents because they're trying to be a pioneer. They're now called meta platforms. They're trying to create something called the metaverse. And right now, in order to make the metaverse work, you have to have this. It's like a virtual reality technology. So they bought a bunch of patents that used to belong to this company called Oculus. Rift, I believe, OR, and so they own patents as well. So Facebook, one of the reasons why Facebook is such a valuable company is that, and that's why I love the movie, is because Facebook either stole valuable ideas, they developed their own ideas, like this beautiful website here, and although part of which is really based on some stolen ideas from the Winklevoss twins, and also Zuckerberg legitimately has bought legal rights to other people's ideas, like when he bought out Instagram, or when he bought out the rights for the virtual reality technology for the metaverse he's building. So let's go ahead then and go into our survey then, now that we've looked at all of this background information. I've given everybody a chance to complete the survey. Now, what I'm going to do here is I'm going to refresh the survey so I make sure I get all up-to-date results here, and then we'll go into survey statistics. And then, like I say, I want to use the survey because this is called the real format. So we only meet 6 times, really 5 times if you exclude the orientation. That's why you only need to do 5 surveys, in the class out of 6. But let's go ahead and I'll use the survey results as a way to introduce you to the main ideas of the law of ideas. Okay, so let's go ahead then and jump in here. We should have a pretty good sample size, by the way, now. So I'm actually pretty excited. That's why I love this section. That's why I record the second section, because I have a better sample size. All right, great. Now, this is a survey, so you get full credit for whatever answer. So my first question is, do you own any intellectual property rights, or have you created any intellectual property rights? There's basically 3 ways, right, to obtain intellectual property. You could steal it the way Zuckerberg did, right? You could create your own intellectual property, which you could say that Zuckerberg also did, right? He probably built on the ideas of the Winklevoss twins. And also, you could buy other people's intellectual property. You could license their intellectual property, which is what a fancy word for. That's what license means. So I can buy the right to use somebody else's intellectual property, or own it outright. If I buy that company out, then I own all the intellectual property that's owned by that company. That's why companies invest so much money in R&D and in developing their own IP. So for you to appreciate this question, though, we have to say, well, what are the main types of intellectual property? And so this is why I like this question, because it's a good survey. What are the main types? How can you answer this question unless you know what is intellectual property? And basically, there's 4 types of intellectual. This will be a little bit repetitive. I gave you a little bit of introduction at the beginning while I was talking about Peter Thiel. But notice there's trademarks. Trademarks are basically brands. That's one type of intellectual property. And, people do use the word brand loosely, like your Instagram page, that's your brand. You may have heard of that, right? Or your LinkedIn page, that's your brand. It's how you want the world to see you. Those are highly curated, right? Maybe your TikTok and your Snapchat, maybe it's more real, you know what I mean? You don't have to wear makeup, or you don't have to be all buff or whatever, perfect lighting, but there's certain websites that you try to promote your quote unquote brand, but we'll see what that means legally. That has a very specific meaning. Copyrights. So basically a copyright is any original work that can be published in a tangible medium of expression. So basically, if you can write it out, print it, record it, tape it, anything like that, can be like a musical composition, a poem, comic book, a screenplay, dance choreography, a sculpture, any creative work. And so, when people talk about entertainment law, what they're really talking about is copyright law. That's what entertainment law is. It's copyright law. Patents and trade secrets, let me just group those together. Those are 2 different ways of actually protecting your actual ideas, inventions, formulas, recipes, valuable ideas. But I'll explain that they're different, what the requirements are to get a patent and what the requirements are to get a trade secret. But first of all, has anybody created any of these 4 forms? I'm always curious. So notice here we have a pretty respectable, usually when I ask the survey question, maybe about 10%, if I'm lucky, 10% on average will say that they've created intellectual, that actually own or have created intellectual property. This is a pretty talented class because here I'm getting 18%, if you want to put in the chat, if you don't mind sharing what you've created, you know what I mean? Or what you own or what you've done. I've had students, actually graphic novels. I've had students who've written like a musical composition. Actually, while if you want to share what your intellectual property you own or you've created, maybe your other classmates might be interested. While you do that, let me just say this is the one question that 82% of you got wrong. It's a survey, so you get full credit just for participating. This is my attendance. Let me just say that not only has every single student in this class created intellectual property, owns intellectual property, and I'll explain why in a moment, but you probably have already created multiple types of intellectual property today alone, just since you woke up and got out of bed, when was the last time you took a selfie? When was the last time you wrote an essay or posted it to this course? When was the last time you wrote somebody a thank you note or a love letter? When was the last time you did a doodle or a sketch? Maybe during my lecture, Anytime you create an original work and that work can be affixed in a tangible medium of expression, boom, you've just created a copyright, just to give you one example. Maybe you also have like a secret recipe for a special dish, like I know I love, like I love arroz con pollo, and maybe you have a special, which is chicken and rice done the Latin American way, with the yellow rice and the delicious, all the kind of sofrito, all the kind of secret ingredients that go in. Maybe you have your own recipe for your favorite dish, maybe you've compiled a list of people that companies you may want to work for, that you may want to interview at. All that, believe it or not, anything that you create could be valuable is intellectual property. Now, that's what I was going to say. I didn't ask you, did you create valuable intellectual property, right? That's up for the market to decide. Is somebody willing to pay you for your list, for your recipe, for your selfies, for your essays, for your poems, for your love letters, et cetera, et cetera, et cetera, right? If you're a good writer, right, maybe you go to Miami, the Miami Book Fair in November, maybe you hook up with an agent, and maybe you get a book contract with a big company, a big publisher in New York, That's why intellectual property is so important. It's the stepping stones. It's how you connect X and Y, to use Peter Thiel's algebraic metaphor, X being having a good idea, and Y being how do I make money from my good idea, So everybody here has created intellectual property. Let me just say that right off the bat. All right, let's do the other survey questions. And I want to begin. Now, I will be focusing on the social network and Facebook. But to be honest with you, Facebook, as successful as a company as it's been, and it's taken a big hit since January when Facebook disclosed in its quarterly report that actually the number of Facebook users has gone down for the first time since Facebook was launched in 2004. Now, that said, Instagram is still growing, still very popular, but Instagram has a smaller user base than Facebook if you look at it worldwide. So I want to actually focus for a moment on Google, because Google is by far the most successful, valuable, powerful, you might even want to say nefarious company in the history, not just in the history of capitalism, in the history of the world. Google is, in fact, let's go check it out right now. Google, actually, they're called Alphabet. Alphabet stock price. It's not yet 4:30, so the market will open. But just out of curiosity, let's see what that stock price is. In real time. I am literally left speechless. It's going to cost you $2,341.39 to buy a single share of Class A stock in Alphabet. So you'll excuse me for why I want to choose Facebook. I'm sorry, why I want to talk a little bit about Google and not just Facebook, because it's a valuable company. Again, why? Well, this question tells you why, right? Let me go back to my survey. Google owns the legal rights to the PageRank algorithm, right? They own the legal rights to their search engine. It's called the PageRank algorithm. They are the ones, they are the, and they're doing a whole bunch of other stuff, right? Google Maps, they have this thing called Go, a very sophisticated, Alpha, a very sophisticated AI algorithm. They have a whole bunch of things that they're doing, but really their main source of income, they own YouTube, their main source of income is that Alphabet owns Google PageRank algorithm, right? The search engine. So how do you think they protect it? Let's see what the class thinks. And what's really interesting, I love these results because they're both right. Google, and in fact, I'm going to show it to you right now. I posted it in the module. Google, when they were started, and you saw their original homepage, Google actually patented. I'll show you their very first patent. They actually patented the PageRank algorithm. But today, every single innovation since 1998 that has been made to the PageRank algorithm, Google Maps, the reviews, Google Books, Google Scholar, all of the additions that have Google now adds to the basic search engine, all of that is protected by trade secret law. So let me just show you, before I explain the difference between a trade secret and a patent, because those are the two ways that you can, if you have a good idea, that you can protect your idea and you can get the law to recognize you as the lawful owner of that idea. So let me show you this to you. It's in the, I never get tired of looking at the original PageRank. The patent, this is probably the single most valuable idea in the history of the world, right? Just in terms of, the most important idea probably comes from religion and philosophy, et cetera. But I mean, the most commercially, monetary, like dollars, you saw the company is worth over, almost, $2,300 a single share. So you'll see here that this is the PageRank algorithm. The inventor is Larry Page. And his address there is listed, Stanford, California, right? He was a student, computer science student, very famously became later friends with Sergey Brin, and they together founded Google. But at first, Larry Page had this idea that he later shared with Sergey Brin, and together they teamed up to create Google. And notice here what's really interesting is that Larry Page assigned, that is to say, he transferred the legal rights to his patent to Stanford University. And this is actually something you need to know for this class, also for your careers. It's called the work for hire doctrine. It's a common law doctrine. The work for hire doctrine is that when you're an employee and you come up with an idea, whether it's a trade secret or a patent or later, copyright or trademark, if you come up with an idea, it belongs to your company, belongs to your boss, basically, belongs to the company you work for. That's the work for hire doctrine. Now, what's interesting in the case of Larry Page, and I have to give a lot of credit to Stanford. You ask yourself, why is Stanford so famous? Why does it have such a great reputation? Why do people want to go to Stanford, for example? And one of the reasons is Stanford was a pioneer in this type of a commercial transaction where they would, if they had like Larry Page, he was a graduate student at the time in Stanford's computer science department. He came up with the PageRank algorithm. So Stanford owns it, right? But Stanford negotiated a deal, or Larry Page negotiated a deal with Stanford. If you give me back my patent, if you reassign it back to me when I graduate, then I'll give you 10%, whatever it was, I'll give you a royalty from all the money I make, from Google, if I make any money. So, and that's exactly what happened. And I will tell you now that it's not just Stanford, UCF, UF, FSU, Harvard, all the big research universities now follow Stanford's lead in terms of if you're a professor doing research at the university or a graduate student, or even an undergraduate student, right, as part of your class, It's interesting, who owns that, right? The university is going to say that they own it under the work for hire doctrine. But what the UCF, at least their Office of Commercial Technology, what they do is they license, they say, okay, you know what? We'll give it back to the people who actually developed the idea, at UCF, but they pay UCF a royalty that we'll negotiate on a case-by-case basis. And so the idea is, okay, great. I'm an inventor. I'm a researcher. UCF is going to pay my salary. I'll come up with a lot of great ideas. Some of them will make money. Some of them won't make money. But UCF and I will make a deal, right? That, okay, if any of my ideas make money, I still own the idea, but as long as I give UCF a cut, whatever we negotiate. So this is actually very, very common now, and that's what Larry Page did. There's one more thing, though, I want to show you of this part of this patent application, and that is the date it was filed. If you look at this closely, it was filed on January 9th, 1998, right? That would be the year Google would be launched in Palo Alto. Now I want to show you, I want you to guess, maybe this should be my next survey question in the future. How long do you think it took for what probably ended up being, or what is, there's no doubt about it, the single most valuable commercial idea, patent in the history of the world? How long do you think it took Larry Page? Actually, he's backed up by Stanford. He had a scientist at Stanford. So Stanford's legal team was the one prosecuting the patent, to use the language. Well, if you go to the top, you're going to see that Larry Page, it took him almost 4 years, 3 years. All right, I apologize for that. I did get disconnected and I wasn't able to get back on, and I'm not sure what's going on. So I thankfully I have a backup device, and so as now the class is perhaps familiar with. So I'll just continue where I picked up. I was saying, what's the difference between a patent and a trade secret? Well, with a patent, it's really hard to get because you have to prove that your idea, your invention is novel, useful, and non-obvious. And that's where we got disconnected. What that means is novel. You have to prove that your idea is new. Nobody has ever come up with it before. Okay. You also have to prove that it's useful. That is, it's a good idea. It has some commercial value, that it actually solves some kind of problem. In the case of the PageRank algorithm, right? That was it novel? There were other search engines, right? But what was novel about the PageRank algorithm, and I'm sorry that with my backup device, I don't have the screen share capability. But with my with the backup, but with the PageRank algorithm, the way it works, what the patent explains, the reason why it was novel is because before, like previous search engines, they would judge, basically you're doing a search on the internet, right? You want to get good results, right? You're searching for, let's say you're doing a research project, and you're researching, let's say you're a finance student and you're researching what is a Dutch auction, right? Or what is a, there are all kinds of exotic types, but I know about the Dutch, or what is the Dutch book theorem, which is a very important idea in probability theory. So you look up Dutch auction, you look up Dutch book theorem, right? You're probably going to get Wikipedia, probably going to get some research articles, et cetera, et cetera. So how does the search engine know to give you what results? The old search engines would be based, okay, how many times does the word Dutch auction appear on a website? That would be one indication, is that website affiliated with a university or is it a commercial website? That would be another way of, of trying to figure out relevance. A lot of little hacks, if you will. What Google did is we don't care about any of that. We don't care whether it's a university site. We don't care how many times the word appears in the page. What we're going to do is different. What we're going to do is we're going to see your web page will get on the top of our rankings if other web pages link to your web page. That's how we decide relevance, by the number of hyperlinks. And so that was actually new and of course useful because it gave you actually more accurate results. But here's why patents are so difficult to get. This is why it took even Larry effing Page, right? The co-founder of Google. It took him almost 4 years to get what would turn out to be the most valuable patent in the history of the world. Well, the reason is because how do you prove something is non-obvious? How do you prove that? It's basically, you have to prove that nobody else would have come up with the idea, even given the existing state of scientific knowledge at the time. The reason why that's so hard to prove is because, well, heck, you just came up with the idea. So if you came up with the idea, how can it be non-obvious? You know what I mean? So it's really, really hard to prove. And if you look at the Google patent, for example, or any patent, you're going to see that patents look and read and feel like scientific articles, because what the patent attorney is trying to do is prove to the satisfaction of the United States Patent Office that the idea is not only new, not only useful, but also non-obvious, that nobody else could have come up with it, even given the existing state of knowledge and technology at the time the patent was filed. So let me just tell you right now, there is no way you can get a patent without an attorney. That's something I'll tell you right now. You could try to defend yourself in a criminal case. I wouldn't recommend it, but, you could probably look up the law and try to do your best, what I'm saying? But a patent, even with a patent lawyer, your application is probably going to get denied on the ground that it's not obvious. And that's why I said with that survey, all of the students were correct, because guess what? Since the first Google patent, what Google does to Alphabet, what they do today is basically most of their new ideas and innovations, they use trade secret law. Trade secret law, there is no registration requirement. There's no expensive filing. There's no need to prove that your idea is non-obvious, novel, or useful. All you have to do to get a trade secret is, actually you have to do two things. One thing is you have to come up with a good idea, commercially valuable idea. How do you prove that? Basically, it's an idea that somebody would be willing to steal. It's an idea that somebody would be willing to pay for. But also you have to prove that you took reasonable steps to keep your idea a secret. And this is going to take me now to the next survey question. I want to show that to you. The next survey question is, now I don't have a screen share functionality, so I'm gonna have to go low tech here, and just show you, like maybe do a reverse camera angle. But the next question is, did Mark Zuckerberg, legally speaking, did he infringe the intellectual property rights of the Winklevoss twins when he sold their idea? Now, let me make this perfectly clear. Zuckerberg stole the idea. We're not going to waste time debating that. Zuckerberg stole their idea of a social network that needed a Harvard email address to access.
There's no doubt that he stole the idea. What I'm asking is, legally speaking, did he infringe on their property rights? The reason why I asked that question is because you learned this last time when we looked at the common law, for example, contracts. There is not a perfect overlap between law and morality. And this is why, by the way, technically, for sources of law, this is why natural law is still debated to this day and is so controversial. Because, for example, with contract law, which is less controversial, we saw that not every promise is legally enforceable, right? Only those promises that are made voluntarily, right, and accepted voluntarily, that parties have capacity, they can consent to the promise, and that are backed up by consideration, right? That are basically supported by something of value. The parties are offering each other something of value. And then of course, the promise itself has to be for a lawful activity, right? So only a small subset of promises are legally enforceable, in fact, right? Same thing with intellectual property rights. So what the class said here is, let me look at the results. And it's really interesting. Let's go ahead and let me see. This is low key, low budget, but you can see for yourself that 59% of the class, 157 students, said that Zuckerberg did legally infringe property rights, and 108 or 41% said no, that's not legally. And the reason why this is actually a close question, again, this is a survey. You get credit however you answered. Think about it. Think about what happened in real life. Remember the ending of the movie? Both Zuckerberg and the Winklevoss twins decided to settle out of court. Now, in my next module, I'll say more about their lawsuit, and I'll say more about why it is most business disputes, in fact, settle out of court. But the reason why this particular business dispute settled out of court is because, on the one hand, Zuckerberg did steal their idea. You know what I mean? And there was evidence that, for example, if you saw the movie carefully, my favorite scene, I'll play it for you in the next class, where Zuckerberg has to admit that he registered the domain name, before he told the Winklevoss twins that their website lacked functionality, So it looks like he stole the idea and then, just developed his own website. Now, I'll tell you, if you read the Harvard Crimson article that I linked to on the module, Zuckerberg himself says it took him about a week of coding, right, to develop the Facebook. Whether you find that credible or not, I'll leave it up to you. If Zuckerberg is telling the truth that he did the coding in 1 week, that means then that he, in fact, you could say, that means he started working on the Facebook after he told the Winklevoss twins their website lacked functionality. But guess what? If I'm the Winklevoss lawyer, I'm going to say, first of all, that's not true, because you registered the domain name before you told us you're going to stop working on our website. And number two, even if it did take you a week to develop your website, even if you are telling the truth to the Harvard Crimson, guess what? The reason why you developed your website so quickly is because you stole our idea. You saw our source code. I saw all the hard work that went into it. So you had an advantage, That's why it only took you a week. So either way, Zuckerberg, whether you're lying or you're telling the truth, you're in hot water. Problem is, like I just explained, in order to enforce your trade secrets in court, you have to prove you're the owner of the trade secret, have to prove that you or your business firm, right, took reasonable steps or made reasonable efforts to keep your idea a secret. And what that means in practice, you always want to consult a lawyer, because trade secret law, unlike patent law, which is federal, trade secret law is common law. So there are minor variations in the laws of all 50 states of the trade secret law. But generally speaking, in all 50 states, a judge is going to want to see some evidence that you tried to keep your idea a secret. And what that basically means in practical, black and white, it means you need to show the judge that everybody signed a non-disclosure agreement, or there's a contract with the confidentiality clause in it. Without that, how do you prove that you took reasonable steps to keep your idea a secret? So that's what's so interesting about the social network, right? The Winklevoss twins, they were lied to, and their idea was stolen. Zuckerberg stole their idea. There's no doubt about it. You know what I'm saying? There's no doubt about it. But whether that gave rise to legal liability for misappropriation or theft of trade secrets, that's a different question, because what reasonable steps did the Winklevoss twins take in order to keep their idea a secret, right? That's going to be hard to prove. Now, what you don't know, what the movie doesn't tell you, and I'll show you in the next class, the Winklevoss twins do have a sworn statement, a declaration under oath by their previous computer programmer, the guy that Zuckerberg replaced. And that computer programmer was willing to testify in court that he made it very clear to Zuckerberg that he couldn't share the source code with anybody else. So actually, in my opinion, I think the Winklevoss twins had a very strong case. And that's why I'm going to explain in my next class why they settled, because they have actually a very strong case. All right, so the next survey question is generic a Google, is Google a generic term? So now I want to talk about trade secret law before I share with you the results of this survey. Trademark law. I'm sorry, did I say trade secret? I'm sorry. It's been a tough day. Trademark law. How do you get a trademark? In the first place, you can't get a trademark, right? And normally generic terms, words like chair, words that are in the dictionary, you can't trademark. Generally speaking, foreign language words that are in a dictionary in a foreign language, you can't trademark. Generally speaking, I say generally speaking because here's how you get it legally. To get a trademark, basically you have to prove, and now to get a trademark, you don't have to register it. There are, trademarks and copyrights, I should say, like trade secrets, originated in the common law. So there's no need for registration. But the reason why, if your trademark or your copyright, which is the last thing I'll talk about in this class, if your trademark, your brand, or your copyright, if it has potential commercial value, or if it is commercially valuable, that is to say, you're putting out products and services that people are willing to buy or use. You know what I'm saying? The reason why you would want to consider federal registration of your trademarks and copyrights is because with federal registration, two things occur automatically. Number one, registration is dispositive proof of who owns the trademark. If you go just with the common law, how do you prove that you were the first one to use that mark? You're going to have evidence. You're going to have to call witnesses. You're going to have to, it's like the Winklevoss twins, right? How do you prove that you took reasonable steps to keep your idea a secret, right? If you don't have any non-disclosure agreements or anything like that to point to, right? You're going to have to call your previous programmer and hope that he gives you favorable testimony that he told Zuckerberg to keep it all a secret. So that's one reason why registration is businesses should always consider not just common law protection at the state level, but actual registration with, at the federal level. The other reason is that by registering your trademarks or copyrights, as the case may be, you get automatic federal jurisdiction. You go to any federal court in the country and ask that court to enforce your rights. And the reason why that's such a big deal is, we'll see this more in the next class when we talk about civil and criminal cases, is that federal courts and federal judges, because they normally handle fewer cases than state courts, federal judges run tighter ships. Their dockets tend to be, not all the time, I'm saying on average, but federal dockets tend to be faster than state court dockets. And also, both federal copyright law and federal trademark law give the judges enormous powers to protect your intellectual property. So not only can you get compensated, and I'm talking about major dollars, for any time anybody infringes your trademarks or trade secrets, or patents, if we're talking about a patent. Also, courts have the power to issue what's called an injunction. They can literally, that's what happened to Napster, right? The court can literally issue a court order telling the business, you have to stop doing business until you stop infringing other people's rights, intellectual property rights. And that's effectively what happened to Napster. That is a sobering lesson. Napster, when it was shut down by the courts, and that's going to be my last survey question, they had 26 million users. You thought Facebook getting 1 million users in about a calendar year was a big deal? Napster got 26 million in around the same time. I'm going to tell you something, and the courts effectively shut it down. So we'll talk a little bit about that at the end as well. Anyways, so how do you get a trademark? And then we'll talk about copyright. Trademark, your mark has to be distinct. The most famous example of this is, and there are two ways of showing your mark is distinct. One way is to say that your mark is either arbitrary or fanciful or suggestive. A suggestive mark would be something like Netflix. That's a business that's devoted to streaming online movies, or streaming movies online, via the web because now we have that technology to do that. So it's called Netflix, right? Internet and flicks as a sort of like a slang for a movie, right? Copper tone suntan lotion, kind of suggestive, right? Arbitrary and fanciful marks, like gas stations like Exxon, Shell, right? That has nothing to do with gasoline, right? But those marks, are used then to brand gasoline, or Kodak for, back in the day when people had, film and cameras, you know what I'm saying? Or now you have an iPhone or Samsung Galaxy, the Apple, right? The Apple logo. That's very arbitrary and fanciful, very distinct way of marketing computer products, iPhones and iPods and MacBooks, etc. Right? All the products that Apple sells. So that's how you get a trademark. Normally, descriptive words and generic terms are not protected by trademark law unless a condition is met. And that condition is unless your mark or your brand has what's called a secondary meaning. Let me give you an example of what I mean by secondary meaning for descriptive and generic marks. Think of like Southwest Airlines. I use that example because I love Southwest Airlines. I love to fly Southwest Airlines. But think about it, right? This is a descriptive term, right? It's technically describing an airline that originally served the southwestern United States, like New Mexico, Arizona, California, and Nevada, the Southwest. But of course, now when you hear Southwest, you're probably thinking of Southwest Airlines. They fly to Orlando, they fly to New York, they fly all over the country. And they even have a few international locations, like I think Montego Bay, and I think they also fly to the Commonwealth of Puerto Rico, which is technically a US territory, but they fly overseas, you know what I mean? So Southwest, right, that's a secondary meaning. The problem is, right, when your mark becomes generic, when people use your trademark or your brand to describe products and services of all kinds, even those of your competitors, right? So what's cool here, look what we have here, our results. Let me see if I can get closer. Sorry for this low budget stuff, but basically a whopping 85% of the class, over 224 students, said that Google is generic. Only 15%, only 41 students agreed with the judge in the chapter that I've included in this module. It's a chapter that I wrote, so I included this case from Arizona, where a federal judge, I think this was back in 2018, if I'm not mistaken, the federal judge said that Google is not yet generic. I think if that case were to come up today, I think it would come out differently. I think Google has been generic term. Now, this is why I saved the best for last, copyright. Why is copyright the best? I mean that in a kind of like a funny way. Because let's say Google is a generic mark and anybody can use the word Google to market their search engines, right? Guess what? Google still owns the copyright, right, to their logo. So even if I'm allowed, Professor Garapufol, I'm allowed to use the word Google to describe a search engine, or DuckDuckGo is allowed to use the word Google to describe their search engine, or Bing, Microsoft is allowed to use the word Google because it's generic, right? Guess what? Google Alphabet Inc. will continue to own the Google copyright, and they will continue to prevent people from using the specific Google logo, right? So like what I showed you here in the survey question, and again, I'm sorry, I have to do it this way. The Google logo, right, that has the word Google in a sans serif font, right, with the different letters in different color scheme, right? So that's why I say, by the way, it's the other reason why I say a good business lawyer, one that has experience and knowledge of intellectual property law, is a necessary business expense, because a lawyer is going to know all this stuff and say, yeah, look, I'm going to do everything I can possible to protect, your most valuable ideas. And that in the case of Alphabet, right, they're going to both copyright their logos, but to the extent that they can still trademark it, to the extent they're still distinct and have secondary meaning or just arbitrary and fanciful, like the word Google is or the Apple logo are, they'll do that too. So let's talk about copyright. And my next survey question is, can you copyright a tattoo? Right? As I explain in my survey question, and by the way, I show you Mike Tyson's face tattoo, and I have a great quote by Mike Tyson. I think it's my favorite quote of all time. Everybody has a plan until they get punched in the mouth. And it's a great quote because I'm going to digress here momentarily, because we are in business college, business school. And, one of the things you do in business is you have like these business plans. Like, let's say you want to do a startup, you're not going to get a loan without a business plan, right? But of course, what's going to happen in real life is the business will get punched in the mouth. Some new competitor will come, some new challenge will happen, a new regulation will come out, a lawsuit will be filed. You get, metaphorically, your business gets punched in the mouth. What do you do now? Your plans are basically worthless, is what, I love this quote by Mike Tyson. So, you can think of all these famous examples, like when Blockbuster, right? They were the largest video chain country in video chain business in the world. In fact, they were the largest chain. They had more locations even than McDonald's. It was incredible, right? Now there's only one Blockbuster store left open in Oregon, and it's only open because people go to it as a tourist attraction. It's not even a real, that's all, so it's probably, well, even that one will go out of business soon, so your Blockbuster got punched in the mouth by Netflix, right? I remember back in the day when I had an RIM BlackBerry. That was the most sophisticated technologically sophisticated, gadget in the world at that time, And of course, they get punched in the mouth by the iPhone in 2007 when the iPhone comes out, right? So you see all these examples of business firms getting, quote unquote, punched in the mouth. You get a lawsuit filed. It's a great quote too, because, in your personal life, you could get punched in the mouth. You get a bad grade. You could, break up in your relationship, go through a breakup. You could, lose a loved one, through disease or, car accident, stuff like that. We're all going to suffer. This is what I like about this Mike Tyson quote. We're all going to suffer setbacks at one point in time. We're all going to get metaphorically, punched in the mouth, so to speak. So it's what you do after that really is going to determine your legacy and who you are as a person. All right, great. So Mike Tyson, can he copyright his tattoo? What's interesting is that all of these lawsuits that have happened in real life, they've all been settled out of court, after either prolonged or some litigation. So this is a question that's still open. It's still pending. Eventually, one of two things is going to happen. Either the United States Supreme Court will decide this question, or the Congress will step in and they'll amend the Copyright Act of 1976 to specify whether you can copyright a tattoo or not. The reason why this is an open legal question is because you could say a tattoo is just like any work of art, right? How is it different from an oil painting, right? As long as it's publishable in a tangible medium of expression, right? And what is more tangible than human skin, you could argue, as long as it's creative, original, yeah, you can copyright a tattoo, right? As long as it's an original tattoo. On the other hand, you may not have known this, but there's an important exception to copyright. One of the few things that you cannot copyright are fashion designs and, articles of clothing. So like today, for example, I'm wearing a dress shirt, and a tie, this kind of thing. So anybody, you can't copyright a design for a dress shirt or a tie. Anybody should be free to manufacture, their own articles of clothing. So what companies do is, for example, like in my case, I have I'm wearing a polo shirt that I don't know if my wife got it for me or how I got this shirt. I've had it for a long time. But so what a company will do is they'll put their trademark right on their fashion, because they can't copyright their fashion design, but they can put a trademark on their article of clothing to distinguish it for consumers that are like polo clothing. Okay, I want the polo shirt. I'll pay the extra $10 or whatever it is at the outlet for a polo shirt versus a shirt from somebody else. So let's see what the class thinks about this. And by the way, this is the discussion post for this module. So our results are very interesting. It's basically 1/3 to 2/3. 1/3 of the class believes that tattoos are more like works of art, and 2/3 of the class would say that tattoos are more like fashion designs. And the reason why I asked this question is just to show you how difficult it is to be a judge and to make these decisions. Because if you think about it, let's be fair for a moment. Let's be, objective, to the best of our ability, right? Both of those analogies are really good, right? You could say a tattoo is like a work of art. And in fact, tattoos are called body art, in the tattoo industry, and I have to say, I'm at the supermarket, I'm at the ball game. People have some really cool tattoos, beautiful tattoos. You know what I mean? I'm tempted to get one, to be honest with you. You know what I mean? But at the same time, you could also analogize the tattoo, like it goes on your skin, so it's more like a fashion article, or a fashion accessory. And those are, as a general rule, you can't copyright those. By the way, Katy Perry's lawyers learned this the hard way. You may have remembered I forgot, I think it was about 5 years ago, the Super Bowl, where Katy Perry had her show. It was a great show. And this whole thing of the left shark became a meme because the left shark was just a terrible, clumsy dancer. And it turns out there's this guy in Orlando who came up with a 3D design, like a design of the little left shark figurine that he would send you, I think for a small fee. You could, if you had a 3D printer, you could print out this left shark. And so you may have heard back in the news back in, it was again, just 5 years ago. So you were probably in high school or junior high. But, Katy Perry got a lot of bad publicity for sending a demand letter, having her entertainment lawyers from Wilshire Boulevard in Los Angeles. I know I grew up there. That's a very nice area of the city. There's one little guy here in Orlando, a little entrepreneur, basically, who came up with this really cool left shark figurine. What you may not remember, the media didn't kind of lost interest in the story, but there was a professor at New York University who specializes in intellectual property law, and he agreed to represent the Orlando entrepreneur for free, pro bono. And basically, he, made it, in his reply letter to Katy Perry's lawyers, made it very clear. Look, this little left shark, because it's based on a costume, and because a costume is an article of clothing, right? You don't have any intellectual property rights to that. And so, by the way, I will tell you, it's actually a little bit more complicated. It's why you need a lawyer. Think of Disney, right? Mickey Mouse. I want to put aside the fact that the original Mickey Mouse Steamboat Willie, I just learned about this. There's a documentary on the Netflix. It actually has a racist origins, and there are some terrible things there. And so, I don't want to go into all of that, but that the Mickey Mouse copyright is, you may not know this, it's actually set to expire next year. That is, unless Disney lobbies Congress in order to get it extended again, like they did back in the 1990s, Well, I doubt that Congress is going to go on with that, because now copyrights have a 95-year term, and that's pretty long. But the thing is, even if the Mickey Mouse copyright expires next year, as it's scheduled to do on January 1st, 2023, guess what? Google owns the trademark to Mickey Mouse, because guess what? I'm sorry, Disney. I'm getting all my companies confused because it's late in the day. But Disney owns the trademark to Mickey Mouse because they sell Mickey Mouse merchandise, right? In the Magic Kingdom and online as well. on the Disney store, right? And at Disney Springs. So that's why, you know, Google, Disney, Google, all these big companies, they work with their lawyers to protect their valuable intellectual property rights. Okay, our trademark is generic. Boom, doesn't matter. We're going to copyright our logo. Okay, our copyright is in the public domain. Boom, it doesn't matter. We'll trademark it and then merchandise our trademark goods, you know, sell them in commerce in order to get trademark protection. All right, so now, you know, one last survey question. And my last survey question has to deal with copyright infringement, and it has to deal with Napster. How is Napster any different from YouTube? Think about it, right? Napster, the way Napster worked is that what you do is when you would sign up, and let me tell you, when Napster came out is around the time you were born, or maybe a little bit before then, because it came out, I believe, in June of 1999. But the thing about Napster is that, but it got, you know, at its peak, 26 million users before the courts shut it down, you know, the lawsuits in the early 2000s. And the way Napster worked was that when you downloaded the Napster app or the Napster application, you know, what would happen is that the reason why I had 26 million users is, first of all, it was free. And number two is you would have access to all the other Napster users who downloaded the app. You would have access to their music files. And then all those other Napster users would have access to your music files once you download the Napster app. Now, back then, it wasn't called an app. It was actually a little bit more cumbersome. You had to do with this on your PC, you know, but I'm going to explain it like in current terms so you can understand how it worked. But it was called peer-to-peer file sharing. And what people found controversial, the reason why Napster fought this is because let's say I'm using Napster, right? And I legitimately bought the music that's in my music files. I went to the Apple store back in the day. It's called iTunes. And I paid 99 cents to get all, you know, for each of the songs that I wanted in my music library. So let's say I have my music library, I own it legally, you know, or license it legally via Apple iTunes, you know? It's kind of how like Spotify and the Pandora work today. Why can't I share my music, you know, through Napster with other users? You know what I mean? Why do the other users have to pay 99 cents if they want to download the song? So this is what it basically comes down to. Right. And I'll tell you, you know, I mean, I'll just, you know, I'll cut to the chase. This case is already decided. It's long decided. And other similar business models that copied Napster. All of these cases have gone up to, you know, the appellate courts. In one case, the Grokster case went up to the US Supreme Court. And all those cases said this was not fair use. You know what I mean? Basically making it available. Because what happens is when you buy songs from iTunes, even though you pay the 99 cents to get the song, you didn't really buy the song, you licensed it. And part of the conditions and a license is just a fancy word for a contract. Part of the conditions of your license is that you can't share it with anybody else, you know, via Napster or via other services. So that's how the courts ended up basically ruling in favor of the music industry. So now I ask you, how the hell is YouTube any different, right? YouTube, people upload videos and anybody can listen to the videos, right? Well, let me show you the student answers here. And what's really interesting is the top answer with 29% was because YouTube is considered fair use. And let me tell you right now that it's a good answer, but it's definitely not the right answer. Because to prove fair use, it's 4 factors. And the thing is that one of the factors, for example, is you know, how much of the work that you're copying and pasting or posting to YouTube, you know, or posting on Napster, you know, are you copying the entire song, the entire movie, the entire TV show, or just a small snippet, you know? And the thing is, you go to YouTube, right? You can get basically the entire song. It's no different than Napster, right? You can listen. That's what I've been doing at the beginning of each one of our first 4 classes. I've been playing off of YouTube the entire song that I've just basically got up there. So that's going to be hard to show that that's fair use, though it's not a bad answer. The second answer was legal representation, because, you know, YouTube, which is owned by Google, is a much bigger, powerful, dominant company than Napster is, you know? Well, the truth is that's actually a trick question. This is a survey, you get the right answer. 31 respondents, so a healthy 12% voted for that answer. It's not a bad answer because sometimes, like, you know, this is what like Morgan and Morgan try to do, right? Or the big law firms try, like Katy Perry's law firm try to do, right? Or we're this big, expensive law firm. We're gonna scare you into submission, you know? Who are you gonna hire to defend yourself? You know, we'll talk more about the litigation process in the next class. But the reason why this isn't a good answer is because think about it, right? YouTube, when it started, was a small, scrappy little company, right? Google doesn't buy YouTube until many years later. Napster was the big powerhouse, you know, with 26 million users. You know, it was scheduled to be, it would have been the next YouTube, you know, if it hadn't been for the courts, right? The next answer choice is because YouTube is willing to share revenues with the music industry. And I got 66 students, 25% saying that. And it's actually not a bad answer because, and I'll show this to you, I have it pulled up. You know, before A&M Records sued YouTube, right? Metallica, actually, they brought the very first, actually, Metallica and Dr. Dre, they both brought the first lawsuits against Napster for copyright infringement. And when they quickly won their lawsuits, because they had registered their, you know, their songs, you know, at the Library of Congress, the Copyright Office, they brought their action in federal court, and the federal courts ruled for them, ordering Napster to take down any infringing music file that had, you know, Metallica or music or hip hop music by Dr. Dre. And that's when A&M Records and the other big record studios came in. Look at now YouTube. What you just saw there, I hope you saw there, is Metallica's official YouTube channel. In other words, right, YouTube is willing to say, hey, look, don't sue us. Why don't you put your channel on? Why don't you work with us? Put your channel on YouTube and we'll share the ad revenues with you. So that's actually a good answer, but think about it, right? Metallica doesn't have to do that, right? They could still, you know, they could, you know, so the actual correct answer, to the extent there was one here, is going to be the third answer choice. Let me go back to the survey and show you that wording. And 34%. So that actually got the most votes. 91 respondents, because YouTube complies with what's called the takedown notice procedures of copyright law. And I want to end the class on this note, and then I'll open it up with questions, comments, and concerns, but I want to end the lecture part of the class on this note, because this is the single most important aspect of copyright law in terms of your daily life, in terms of your own activities, in terms of, you know, how you interact with the law, intellectual property law generally. Because but first of all, the big difference between YouTube, which is owned by Google, and Napster is that when Napster got the takedown notice from Dr. Dre, when Napster got the takedown notice from Metallica, when they got the takedown notice from A&M Records and the other big record labels, they just ignored it. They said, sue us. We're going to allege fair use. We'll see you in court. When YouTube gets a takedown notice, they don't even play, right? They take it down immediately. In fact, some people think YouTube goes a little bit too far because YouTube sometimes will not wait to get the takedown notice. YouTube has their own algorithms, and they're kind of there's these preventative takedowns where if YouTube believes you're infringing intellectual property rights, they'll just take down your stuff even without waiting to get the notice. So notice now, why did Napster lose? Why did Napster lose, you know, in the fair use defense? You know, that's why you have the takedown notice procedures now, because if you feel you're fair use, you say, hey, take me to court. You know what I'm saying? I'm going to allege fair use. I'll let the judge figure it out. Well, Napster lost fair use because although fair use is 4 factors, the most important factor is what effect does the alleged infringement have on the market for the infringed work? What that means is, when somebody is using your work without authorization, is it actually helping you to increase your sales? Because now more people know about your music or know about your work or know about your ideas? Or is it actually cannibalizing sales? And now nobody is buying your work because they can just get it for free off the internet. And of course, in Napster's case, and I'm sorry, I had the graphic, but I don't have it with me right now. But in Napster's case, CD sales, you know, once Napster grew, CD sales declined precipitously. And in fact, the record industry, the music labels, they had to change their entire business model. Now, today, because of that, even though Napster lost, now the music industry, they make most of their money through licensing arrangements with Spotify and Pandora and other streaming services. So it's like, because nobody's willing to pay, trust me, no one is willing to pay $20 for a CD. I mean, maybe Adele, maybe Taylor Swift, maybe Bad Bunny, maybe there are a few musicians that I know their entire CD is going to be pretty good. So maybe I'll shell out 20 or 25 bucks for a CD. But most CDs have at best one or two good songs. And so I'm just going to, either get it for free through Spotify, or I'll pay the 99 cents through iTunes, right? Et cetera. Now, so that's what we have now. You know what I mean? Now let me share. Let me just let you know that the reason why we live in this world today is because it's Congress in 1998 enacted, and President Bill Clinton signed into law the DMCA. The DMCA, I know it sounds like Run DMC, the original hip hop group from the 80s, but the DMCA stands for Digital Millennia Copyright Act. So the idea is that Congress was going to modernize intellectual property law, copyright law specifically in the internet. And what Congress did that was still kind of controversial, Congress said, you know what? We're going to extend copyright law into cyberspace. So you have to understand, before you were born, the internet, the original goal or dream of the internet was that it was going to be a libertarian paradise. No sales taxes, no rules or regulations, no IP, intellectual property, none of that. It was going to be, you could do whatever you want. You know what I mean? As long as no, there was always the question of, can you use the internet to transmit a physical threat? And their courts would have to decide, well, how imminent was that physical threat? So yeah, you could even do physical threats and hate speech, because really it was a medium that was, asynchronous, you know what I mean? And so that was the original libertarian sort of dream of the internet. But if you've bought anything on Amazon lately, now you pay sales taxes, right? Now, all these websites have content moderation policies that, even though hate speech and, technically is protected speech under the First Amendment, right? The First Amendment only applies to the government, not to a private company like Twitter or Facebook. So they can have their own content moderation policies, including censorship, if that's what they want to do, Now we'll talk about, by the way, whether they can do that and whether these companies are monopolies, what I'm saying, in the last class. We'll come back to that. But that's at least the existing state of law. So the Digital Millennium Copyright Act is the first big piece of legislation to shut down the libertarian version of the internet. I say this because, I'm very sympathetic to the libertarian viewpoint. And so what the Congress did is, we're going to extend copyright law to the internet. If you post copyrighted material without authorization on the internet and it's not fair use, you could be legally liable. You know what I mean? If you post a link and that link goes to copyrighted material, that link could be considered copy. I mean, this was a big deal when Congress made this policy decision to extend intellectual property law to the internet. But at the same time, let me tell you, Congress made a very important compromise, and I think personally it's a fair compromise if we're going to extend IP law to the internet. Which I'm one of the critics of that. But if we're going to do that, the compromise is that, okay, in order to enforce your copyrights on the internet, you first have to send a takedown notice. In other words, you have to give the infringer, I should say the alleged infringer, because the infringer has the alleged infringer has a fair use defense, most likely, right? And they have their day in court to litigate the fair use defense. But you have to give the alleged infringer an opportunity to either take down, the infringing material, or to say, no, I'm not going to take it down because I'm going to assert fair use. So you sue me in court. I'll take my chances there. So I call that a compromise, because if you think about it, the way this works in real life, Now, all of the entertainment companies, all of the record labels, all of the Hollywood studios, all of the TV, companies, now they have to hire a bunch of people to monitor YouTube, to monitor all of these websites, to monitor social media, to see who's posting infringing stuff. And even after they've done all that monitoring, they still have to send an individualized takedown notice that complies with the DMCA, that identifies what is the alleged infringing material, and give the other party a reasonable time to take it down. That's why I call it a reasonable compromise, because now, we all have a safe harbor. We can basically do whatever we want on the internet. But if you get a takedown notice and if you think it's fair use, you can just disregard the takedown notice and fight it in court. If you concede it's not fair use, you can take it down and avoid legal liability. And so that's the difference between YouTube and Napster. YouTube actually takes stuff down when they get the notice. In some cases, they even don't wait to get the notice. They'll just take it down preventatively. And Napster never did that. And so it goes to show you why the law is so important, because Napster, can you imagine that? A business that had 26 million users was effectively shut down by the courts because of the court said this is not fair use. This is a copyright infringement. Now, one last thing I want to make. This is sort of like my. This is why you have to watch your politicians, your elected officials very closely, especially the ones that are in Washington D.C. Because the entertainment industry, as I speak, they're lobbying for something called. These guys have the big money, right? We're talking about Sony, we're talking about A&M Records, we're talking about Warner Brothers, right? They have the big bucks, they pay the lobbyists. And there's a bill pending before Congress called the Stop Online Piracy Act. What that bill would do is it would undo the 1998 compromise. What it would do is it would basically remove the requirement for having to send a takedown notice. Basically, the moment that you infringe on, post copyrighted materials without authorization, you would be subject yourself to legal liability. You wouldn't have the opportunity to take stuff down. To me, that would be a complete game changer. And you may not remember this because you were probably actually beginning junior high or ending even elementary school, depending on when you were born. But you may remember that Wikipedia went offline for 24 hours. You may remember that Google had a big black censorship tape over their world famous logo. On January 15th of 2016. And this was because the Stop Online Piracy Act was about to be scheduled for a floor vote in the House of Representatives. And these big tech companies and Wikipedia and the big nonprofit, right? In part because of the pressure they put, those plans were put on hold and the vote never took place. But I got to tell you, the entertainment industry is still working hard, to modify the DMCA. Because think about it from their perspective, right? If you own valuable intellectual property, movies, songs, compositions, etc., right? Do you really want to be required to spend all this money monitoring the internet and sending down takedown notices and giving people the opportunity to comply? You would like to have more powerful tools at your disposal. Of course, I'm talking here more from the consumer perspective, right? I would like to have the protection of the takedown notice, which I think is a reasonable compromise, though, that's the stuff that's being debated in Washington, D.C. as we speak. Okay, that pretty much, we are out of time now as it's 4:30. What I will do is I will stay on the line. If anybody has any questions, comments, or concerns, go ahead and put those in the chat, and I will, otherwise you are free to go. We are done for the day. By the way, I hope I'm still recording this. I don't know, because I'm on my backup device. Hopefully this is still being recorded. But I'm not being given the option to close this recording. So any questions? Let me go into the chat. Let me see what's going on in the chat here. Yeah. So okay, this is some good comments in here. 2 comments here. Vinyl has come back, and that has to do more. That's markets, and vinyl technically superior if you have the right equipment. Vinyl is technically superior to MP3 to digital music files. That's if you have the right equipment. Also, there's a bit of nostalgia for the vinyl records, right? Etc. But notice that vinyl records are making a comeback, but it's still a very small percentage of revenue stream. You know, most of the revenue being made by the music industry is now through their licensing deals with Spotify and Pandora. Now, this raises a whole other question: that are these licensing deals, are the musicians being fairly compensated, right? We know the music labels are being, getting huge amounts of money with these licensing deals, but there's some question that the musicians themselves are not getting a fair shake. And this has to do not so much with the Spotify and Pandora. This has to do that the music industry traditionally, it's why if you are a musician and you get an opportunity to sign with a label, you really need a lawyer, because that signing agreement is going to have a lot of language that's favorable to the label, you know, and so for new musicians, this becomes a huge issue. That's why I like to play hip hop music also, because a lot of hip hop musicians, but this is spilling over to other music as well, country, etc. A lot of other musicians are now creating their own labels, you know, and Jay-Z is actually the guy, you know, made a big deal about this, and got the ball kind of rolling. You know, why should these big companies get all this money? Let's have our own label where we're more equitable. We share more of the profits with the musicians who give us the music. And so I actually had a student in my class when I taught in Puerto Rico. She was a big merengue singer. You know, when I saw her contract, it was Sony Records too. You know, I can vouch for this personally. The other thing I want to tell you, somebody said about striking music entire channels. This is a big problem. And one of the things is, like YouTube and other social media platforms, what they'll do is, like, if you're a repeat offender, like if you're generating a lot of takedown notices, the companies do reserve the right to take down your entire channel, including the stuff that's legit, you know, that's not infringing on people's copyrights, you know. And this is actually a very explosive issue, because it's one thing to take down stuff, you know, if there's a takedown notice, and if, you know, there's a debate about whether it's fair use or not. But it's quite another thing to take down an entire channel. And this goes to the problem that I will address in the last class. Are these companies too big, and are they abusing their power? And what we'll see is the big area of law that applies to these potential abuses of power is going to be antitrust law. You know, when these companies become monopolies, then the law can come in and can take some remedial steps to actually, you know, interfere in their business models. But we'll see that we'll see what those requirements are in the last class, because that is a legit question. Are these big tech companies now, you know, even if they're not legally speaking monopolies, are they just too big and powerful that they even threaten democracy? That's a legitimate, fair question. So let's see what else is in the chat. Let me go into the chat. Now, I don't have the original chat transcript with me because I'm on my backup device. About tattoos. Oh yeah. So so tattoos. Let me just talk about tattoos. Totally open legal question. So that's the debate. Should tattoos continue? If we treat tattoos like fashion designs or, you know, fashion accessories, then tattoos, yeah, you could basically go anywhere and copy anybody's, you know, tattoo. Go to Pinterest or go to the tattoo studio, you know, and you know, you don't have to pay any licensing, anything like that. Just pay for the tattoo. You know, if you go the IP route, if you say that tattoos are copyrightable, now it becomes a whole different ball game, right? Now you could technically be infringing if you have a tattoo that's based on a design that somebody else, you know, came up with, and you don't have that explicit authorization to have that design. Let me tell you why I think ultimately, if this case does go to the Supreme Court, why. First of all, I'll make 2 points. Judicial philosophy matters. If you're a conservative justice, technically, you only apply the law. You don't make stuff up, you know what I'm saying, to update the law, living constitution, etc. You just apply the law. If the law sucks, that's up to Congress to fix. So if I'm a conservative justice, I would be very tempted to say that a tattoo is copyrightable, because even though you have the analogy to a fashion design, I'm going to say that, you know, a tattoo is more like a work of art. It's like a little drawing, and as long as it can be published, on human skin or even transferred on a whiteboard, or on a poster, that's what the law protects. Copyright law defines works very broadly to be any original work, as long as you can publish it, in a tangible medium of expression. And the exceptions are very narrow. Now, if I'm a more liberal justice, I may want to look at public policy. And here's the problem with extending intellectual property rights to tattoos. What's the penalty? What's the remedy for infringing someone's intellectual property rights? I said at the beginning of the class, one of the advantages of copyright and trademark registration and patent registration is that if a court finds that somebody is infringing on your IP, on your copyrights, marks, or patents, they can not only award you substantial money damages, they can also award what's called an injunction. That is a fancy word for a court order requiring the other people to cease and desist their infringement. And this injunction is a very powerful remedy because it can also be backed up with monetary penalties. For every day you fail to comply with the injunction, we're going to add an extra $1 million or whatever it is as your penalty. But also, injunctions can be enforced by sending people to prison, and judges have these very powerful, these very big panoply of powers to enforce their court orders. And the problem is, think about it. Let's say I'm wearing let's say I get somebody else's tattoo and I don't pay, the fee for it, and I'm fined I'm infringing. Can you throw me in jail because I have somebody's tattoo and I refuse to remove it? Can you force me to get laser surgery, laser removal surgery, right? That sounds like now we're in a very dangerous position. So liberal generally speaking, and there's changes, depending on the issue and the times, but liberal judges are more open to public arguments based on public policy. And we might say that even if literally tattoos are like little works of art, we might say as a matter of public policy, as a matter of avoiding these very ugly consequences, of sending people to jail potentially, because copyright law has both civil and criminal penalties, of laser removal, forcible laser removal if somebody's wearing a tattoo without authorization and it's not fair use, So you could see that those issues of public policy might come into play. The other factor is whether you're conservative, Brett Kavanaugh or Neil Gorsuch or Samuel Alito, or whether you're liberal, Sonia Sotomayor, Elena Kagan, the new Justice Ketanji Jackson, or whether you're kind of moderate, Justice Stephen Breyer and Justice John Roberts, they have tended to vote both conservative and liberal. All of these people are old people. I wonder how many judges on the Supreme Court or how many of their law clerks actually have tattoos, on their bodies. And that raises to me a really interesting sociological question is it really fair to have a judge who's never really worn a tattoo, doesn't know anything about tattoos? Is it fair to have a judge decide this kind of things? Shouldn't this be up to juries? And that's a good little preview of my next class when I talk about civil and criminal cases. And I'll talk about when judges get to decide a case and when juries get to decide a case. You'll be surprised, but for good or bad, and I'll give you the pros and cons, I'll be fair and balanced, but for good or bad, the power of the jury to decide cases has been ever so reducing year after year, decade after decade. In some countries that are common law countries, juries are not even used anymore. Just to give you some example. Now, the United States, we still use the jury, and the jury still plays a very important role, although it is a diminishing role, and for reasons I'll explain in my next class. Okay, great. Any other questions, comments, or concerns? Throw them in the chat or unmute yourself. The quiz. So let me make a few comments about the quiz. Please wait until the Friday office hours, because what I'm going to do on Friday, I'll go over all of the quizzes back then. Right now, I don't even have the screen share. My internet went completely out. I'm using cellular data now, so I wouldn't be able to do screen share. It was brought to my attention there was a mistake in my previous quiz. 2 questions only had 1 answer choice, so everyone is going to get those right. Let me just make that clear. You know what I'm saying? That's nobody got penalized. That was a mistake on my end, and mistakes on my end, students don't pay a price when I make a mistake. So there were, let me just reassure everybody, for those, for questions that are poorly designed or only had one answer choice, you automatically got that correct. Now, when is a question poorly designed? So I don't mind going over my own quizzes because that keeps me honest. So I will go over, I think already at least probably two quizzes. Yeah, at least B, the one for B, I think one quiz is already closed. If there's and then C will close on Monday. So yeah, I'll go on Friday. I'll have a little bit more time, and I'll be happy to go over the quizzes. And also if you can't wait till Friday or can't make Friday, feel free to email me. A little tongue twister for me right there. Feel free to email me. I did respond to all the email. I got caught up last night, and I'll get caught up again tonight as well. But yeah, I'll be more than happy to go over the quiz. And I'm considering maybe, I got to do that in real time. I would post a recording, but some of the questions I do use again. So I have to figure that out, but yeah, by all means. Let me see, anything else in the chat? Let's see here. Okay, great. Yeah, so fantastic. So I wish everybody then a great rest of your day. Next Tuesday is class number 5. It's our next to last class. Between now and then, tomorrow, I'm going to post the guidelines for the final project. It'll be very simple and straightforward. You'll have no trouble because it's all based on the modules. And I'll give everybody until the last day of summer A, which is June 25. Since I wasn't able to post the final project today, the guidelines today, because my class did go over, I'm going to post it tomorrow I'm going to record an explanation video, and then I'll give everybody that till the very end of summer A. So it'll be a very fair assignment, and then of course I'll have the email open, and then I'll say more about it in the beginning of our next class. Yes, you will pick at least one other person, and it's to your advantage to work in a small team. First of all, I'm required to do that because we're supposed to do group activities in this format. So yes, the final project will be 2-person groups, but you're free to have bigger group if you're able to, get a third or fourth person, but at least 2 people. The reason why I want you to do that is for 2 reasons. One, I have to do that. This is we're supposed to be doing group activities. And number 2 is I want you to meet at least one other person in the class, even if it's by Zoom. But number 3 is you can divide the work. Now it's just half as much work. You know what I'm saying? So trust me, you do want and I'll send you the guidelines for that and how to find your partner and stuff like that. It'll be all straightforward and simple. But I will be doing that tomorrow because I am making a few minor modifications to the final project. All right, great. So I wish everybody a great rest of your day. God bless, charge on, and see you in 1 week. Bye-bye.